I'm going to talk a little bit about common law, and bear in mind, I'm a social scientist, so what I find particularly appealing in my role is being able to treat privacy as both a fundamental human right, but also, a legal concept, and that's exactly where Bermuda sits. Bermuda sits at this kind of hub. In terms of being a British overseas territory, in fact the oldest and largest self-governing British overseas territory. Here in front of you, I provided you with some key outlines so that you understand how old common law is actually, and it dates back to 1612. So obviously, in terms of socio-cultural concepts, this is something that is very important in terms of understanding privacy, and obviously some socio-cultural concepts that are common to other BITPA countries. And of course, what is important is to also be mindful of the fact that, the government of Bermuda was reconstituted by the Bermuda Constitution Order in 1968. So a lot of time has passed in the meantime, but the common law doctrines of equity and acts of Parliament of England are still very much recognized and considered to be enforced. And also this really relates closely to privacy and data protection. Bermuda has enacted its own legislation, and its own common law and equity have been developed in Bermuda courts with much influence from other common law jurisdictions. However, when we look at decisions by UK courts, those are usually considered highly persuasive. So for instance, when we look at decisions by ICO in the UK, it's something that will be highly persuasive in Bermuda as well. So those common threads are very, very important. What I want to say additionally is that certain UK acts have been extended to the island. So if we look at, let's say, the Human Rights Act, and specifically the European Convention on Human Rights, those instruments were extended to Bermuda in 1953. So Article 8 of the European Convention on Human Rights could technically, if there is a violation, it could technically end up before the European Court of Human Rights. And we have seen certain cases ending up before the European Court of Human Rights. Interestingly, the only one, not some, the only one that has ended up before the European Court of Human Rights is the same-sex marriage case, which is currently being reviewed by the European Court of Human Rights. So it's the only time that actually Bermudians have utilized this mechanism. And again, we're looking at the common threads that, have been extended to, this structure, thanks to being part of this bigger family of countries. So I will move on to, actually let me skip this slide and I will come back to it later. I would like to say a little bit more about Bermuda sitting at the crossroads of what you might term Europe and the US or the Americas. So our data protection law, our privacy law is called the Personal Information Protection Act 2016, or PIPA. PIPA actually, PIPA came into full force on the 1st of January 2025, but it was adopted, or portions of the act were adopted and enacted in 2016. So our office actually had quite a lot of time to do quite a lot of educational and awareness-raising activities. I will come back to it if there is time. But what I want to say is that when you look at the act, which I have brought with me, if anyone's interested, it's modeled on a couple of provisions. So when you read it, you will recognize two things. You will recognize the GDPR, and you will also recognize other pieces of legislation, such as Alberta's PIPA. And a very good example of Alberta's PIPA is general powers of the Commissioner. So again, if you look it up, and go to Part 4, role of the commissioner, and compare it with our legislation, it's pretty much the same wording. So I think, looking at what our office has been emphasizing, what our commissioner has been emphasizing, that, Bermuda sort of marries the kind of European approach, which looks at fundamental human rights, and then looks at, the Americas, and especially North Americas, where privacy is seen differently, and we try to marry the two. PIPA gives a lot of space, it gives a lot of flexibility, it's not as specific as GDPR, it's much broader, so obviously it also offers more interpretation.